This is in your state and on your screen, your no bullshit guide to how your state is or isn't protecting your digital rights. Today, we're covering the end states. This is part one. Nebraska. Nebraska passed the Data Privacy Act, LB 1074. It gives residents core privacy rights like we've heard so far in this series, the right to access, correct, delete, and download personal data, the right to opt out of targeted ads, data sales, and profiling that affects things like housing, credit, or employment. Businesses also have 45 days to respond to these requests with one possible extension, and there's a 30-day cure period which lets them fix violations before the Attorney General steps in. Importantly, only the Attorney General can enforce this law, so individuals can't sue on their own. What makes Nebraska different is that it doesn't tie protections only to revenue size or number of customers, so more businesses, including smaller ones, will need to pay attention. And that matters because while most people focus on big tech, small and mid-sized businesses also collect and process a lot of data. We can't just protect consumers though, we also need to help these organizations understand what they're collecting and why it matters. Also notable, Nebraska passed 2 other laws in 2025 that touch digital rights. Parental Rights in Social Media Act, which requires age verification and parental consents for minors' accounts, and the Age Appropriate Online Design Code Act, taking effect in 2026, which limits dark patterns in tracking for kids. So Nebraska might not be leading the national conversation, but it is building a framework that will affect more people than you think. Next up, Nevada. Even though Nevada doesn't have a sweeping consumer privacy law, it doesn't mean it's standing still. In 2023 and 2024, Nevada lawmakers started targeting specific kinds of digital surveillance, especially around location tracking and health data. Nevada is part of a growing number of states looking to regulate geofencing, which is when companies or apps set up virtual boundaries around real-world locations. Once you cross that invisible line, say by visiting a clinic, your phone can trigger data collection or targeted ads, often without you realizing it. This is a big deal for reproductive health, especially after Roe v. Wade was overturned. Lawmakers and advocates are worried about companies collecting location data near abortion clinics, addiction treatment centers, and other sensitive places, and then selling or sharing that information. In response, Nevada has signaled strong interest in stopping this kind of digital surveillance by proposing laws to ban or restrict geofencing around health facilities. So if you live in Nevada, you don't have broad rights to access, delete, or opt out of data use. There is momentum on the health front and growing awareness that where you go is just as sensitive as what you post. New Hampshire doesn't usually make national headlines for tech policy, but in 2024, it passed one of the more serious state privacy laws. The New Hampshire Data Privacy Act, SB 255, went into effect on January 1st, 2025, and here's what you need to know. The rights that you have include knowing if your data is being collected, the right to access it, correct it, or delete it, download a portable copy, and opt out of targeted ads, data sales, and automated decisions that impact things like credit, housing, and jobs. What makes this bill different than others is that you only need to affect 35,000 people a year for the law to apply, which is lower than most states. Companies have to collect only what's necessary, so no hoarding of extra data. And you must consent before they can use sensitive information like race, health, or biometrics. They also have to honor universal opt-out signals from your web browser. You can't sue directly, but if you're denied your rights, the Attorney General's office can step in, especially after 2026 when the grace period officially ends. New Jersey. New Jersey officially joined the privacy game in January of 2024 when the governor signed S332. Which went into effect January 15, 2025. It follows the same general model as states like Connecticut and Colorado, which is very good, giving you the right to know what data is collected, to access, delete, or correct that data, opt out of targeted ads, data sales, and profiling, and send universal opt-out signals through your browser. But like many others, there's no private right to sue, only the Attorney General can enforce that. So if you're in New Jersey, make sure your privacy tools are set up, your opt-out signals do count. And if you're running a business, start preparing now for compliance. Use this moment to talk about data rights in schools, clinics, advocacy works, and wherever data is being collected. New Mexico, no law yet, but pressure is building. As of now, New Mexico doesn't have a comprehensive consumer data privacy law on the books, but that doesn't mean nothing is happening. Advocates and lawmakers have introduced privacy proposals in recent years, and the state has held multiple public hearings focused on how to protect residents from exploitative data practices, especially around healthcare access, location data, and youth safety. New Mexico's Attorney General also joined multi-state investigations into big tech's data practices, signaling growing interest in enforcement even without a state law in place. If you live in New Mexico, this is what you can do. Stay updated on public hearings. Many privacy bills get shaped behind the scenes, and hearings are your chance to speak out or submit written testimony. Track the bills and hearings via the New Mexico legislator site. Contact your state representatives, ask them to back strong data privacy protections, especially ones that center marginalized communities and not just corporate compliance. All right, New York, this is a big one.